How are we going to pass that real estate exam? We're going to prep with national questions and Texas state questions for those in Texas. National applies to everybody. That's what we're going to do it with. And of course, you're prepping with Wild Lily Handy of YouTube Agent Prep. All righto. So for anybody that is on Facebook, remember to go to StreamYard.com/Facebook and give StreamYard permission to post your name, okay, on StreamYard. So Facebook is very strict about your names, your accounts. In order for us to see your name on here, like I'll show you here, in order to see your name like here, YouTube Agent Prep, instead of just Facebook, go to StreamYard.com/Facebook, any of you that are watching it on Facebook. I would prefer that you watch on YouTube, okay? Because of course, it helps my analytics with YouTube, and YouTube will promote the channel more, and it encourages me to do more of these classes. And just a note for anyone watching the replay, these classes, webinars that I do are designed to help students participate during the live. And I ask them to type in the question number and the answer. So whenever you're watching the replay, hey, just fast forward, all right, and realize that this is actually to help students prepare during the live session. Hi, Javiola. Hi, Jaylene. And so I interact with the students online, and you can join us on future sessions. If you're watching the replay, I do this on Monday and Wednesday nights at 6 p.m. Central Standard Time and Saturdays at 10 a.m. I've been doing this for over 9 years, only on YouTube for about a year and a half. Prior to that, I have a private Facebook group called Agent Prep, Real Estate Sales Exam Prep. Okay, and it's called Agent Prep Real Estate Exam Prep Group with Wild Lily Handy, and that's a private group. So there's no spamming, there's no advertising, anything like that. It's just to help students prepare for the exam. All right, so let's get going here. So let me post this on Facebook. And since I use StreamYard, okay, which you see on here, I stream to two Facebook pages and to YouTube. So in the future, you may end up doing the same, and you can come and talk to me. All right. Because I learned a lot about YouTube, Facebook, Twitter, TikTok, Instagram during COVID. So COVID made a big impact on the world, and it caused me to change from my prior red company to EXP. All right. Okay. So this is the book we're using, and I do have rights to share the book and show it. It's down in the comments. You can order the book. There's a book for at least 25 different states that you can purchase through my Amazon link in the description. There are other books that I have posted on there that I also like to use, and an old one from 2006, Texas Real Estate Sales Exam, 4th edition, that you can download for free because it is for free on the internet. You know, it's an old one and they don't publish anymore. All right. Okay, so we did that last week, or actually on Monday. And today we're continuing with number 126. I'll minimize this and I'll hide that and show you a better screen. Hi, Jaylene and Fabiola and Ruth. Thank you for joining us. Hey, I just want to share some successes before we get going. You wonder, hey, do people really pass these exams, students? Yes, they do. I had a student pass yesterday, passed both the national and the state. He attended our class on Monday. And today, Cindy Cook passed the national. She's been participating and pass the national, which a lot of times is the hardest. And some individuals think the state is harder. Hi, Kamanani. Yeah, so Cindy's not on here. She'll be joining us for the state portion since she passed the national. Now, Ike, he passed the both state and national. And we talked about EXP today because he learned about EXP on Clubhouse and other people. Okay, so a little bit of, testimonials and successes. They posted their comments on YouTube, so you can see their comment. And one of the things that they stressed, both of them, a lot, is to learn your vocabulary. You're not going to make it without learning your vocabulary. Unless you're an expert multiple choice test taker, which most people aren't, you need to learn vocabulary. Okay? All right, let's get going here. All right, number 126. Let me make it a little bit larger. So that anybody who's watching it on a cell phone can also see it. All right, an estate at will. Okay, on Saturday or last week, we reviewed a lot of vocabulary about this. So what is an estate at will? A, cannot be terminated. B, is terminated only if so stated in the lessee's last will and testament. C, terminates on the death of lessor or lessee. Or D, terminates on the date specified in the lease agreement. So type your answer in the chat, and I will give you an opportunity, okay, to type the answer. So for those that are watching the replay, hey, you can just speed up, okay, and move on to the next question. All right, so I've got C. So congratulations to Cindy Cook. Yes, God does answer prayers. Yes, he does. So David says C. Anybody else? Fabiola says C. And yes, the answer is C. It terminates on the death of the lessor or the lessee. Okay, and that's an estate at will. That means that it could be a year lease, okay? However, as soon as the lessor or the lessee passes away, it terminates. It doesn't have to be, of course, to the end of the lease. And if the owner also passes away, then, of course, it goes to the remainder man or whoever they left on the will. Yes, prep agent and I always refer to doing vocabulary, okay? That's very true, Kamanani. He's an excellent instructor, also on YouTube. I used to use his vocabulary videos and, darn it, and share them with my students during my classes that I would do in person. This was, oh my gosh, 8 years ago, 5 years ago. And so he got a lot of views from us watching his vocabulary videos. So I highly recommend them, okay? All right. So 126C. All right, number 127. A tenant continues to occupy an apartment after lease expiration without the consent of the landlord. This type of estate is called what? An estate of sufferance. B, a holdover estate. C, a canceled leasehold. Or D, a hostile leasehold. So remember, when somebody is, Hey, there she is, Cindy. I mentioned that you passed the national and also Ike. So you were congratulated by Kamanani. All right. And God answers prayers and congratulations. And he also says, thanks, Cindy, for saying what our prep agent tells us and that study vocabulary. Okay. So thanks for joining us, even though you passed the national. Provide some support here and any comments that you want to recommend on here on how you prepared. Hey, this is the time to do it while students are watching nationwide, because you passed the national, and the national exam applies to everyone nationwide. Okay, except some states, the national and the state exam are combined, like in California. In Texas, it's two separate exams. However, the national questions are the same. All right. So anyway, what is number 27? So far, I have A. Yes. So 27 is an estate at sufferance, right? Who's suffering? The tenant or the landlord? The landlord, right? Because the lease expired and the tenant stayed there. So they're called a deadbeat tenant or a squatter. Okay. Bye, Bailey. And so that's the doggy that I walk and jog with, or she walks me. Okay. So an estate at sufferance, because the landlord is suffering. Now he's got to pay money in order to evict that tenant, and that tenant is not paying money. And I've been there, done that. I swear, some tenants are very knowledgeable and they know how to get at landlords. And then there's some really ugly, bad landlords out there too. Okay. So, all right, number 28. A tenant without a lease has been sending the landlord monthly rent checks, and the landlord continues to accept the payments. What kind of a leasehold estate exists? An estate for years? B, estate from period to period? C, estate at will? Or D, estate at sufferance? So we already know it's not an estate at sufferance, right? Because the landlord is accepting payments as the tenant continues to pay. It is not an estate at will. So it is an estate from period to period. Great, Fabiola. Okay, it's an estate from period to period. Okay, some of you said estate for years. No. Okay, estate for years, okay, is going to be more for a person that is allowed to, well, yes, it can be an estate for years if they have a lease and it keeps renewing. A life estate is when somebody's allowed to stay there for the rest of their life and once they pass away. But an estate as will means that either one can terminate at any time without cause. So number 28 is an estate from period to period. Why? Because it says the landlord monthly rent check. So without a lease, a tenant has been sending the landlord monthly rent check. So they may have had a lease on a 1 year and it expired and the tenant continues to stay there. However, they're paying the monthly rent and the landlord is continuing to accept them. So what kind of leasehold estate, right? Leasehold is when it's for tenants. That is an estate from period to period. So it goes every month to month. So Kamanani says, actually in Texas, you get 85 national questions, except in one of our prep books, the Texas Real Estate Exam, Sales Exam 4th edition, that one has 80 national questions and 30 state questions. It's an old book, excellent book though, okay? Just like this book here from Meddling is also an excellent book. And I love them because they have the questions and explain the answers, and they have review on all the different sections that you test for. So estate from period to period. You know, I keep harboring about knowing your vocabulary, but don't feel bad if you don't remember them. Okay, sometimes I forget something. Okay, for example, okay, last night, I don't know why I had the word caveat emptor, and I'm like, holy cow, I don't use that regularly, caveat emptor, empty. So I had to look it up. And what's that? Buyer beware, right? That buyer should review all documents and also tenants and stuff. So beware the buyer. So number 29. Oh my gosh, look at that. David is far ahead of us. Number 29. A fee or life estate is held by an individual. This form of estate is referred to as A, tenancy and severalty, B, tenancy by the entirety, C, absolute fee simple, or D, legal fee simple. So remember, a fee, they probably mean a fee simple estate, or life estate is held by an individual. So this form of estate is referred to as, so if someone has a fee simple estate and it is held by what? An individual. That is the key word here. It is tenancy in severalty, right? So that person has an interest in real property, real estate, and it's only one person. It could be one entity. So that is tenancy in severalty. Very good. David, Fabiola, Jaylene. Okay, Kamanani is having issues with the internet. Yes, and I have issues a lot of times because this is when most people are on the internet. Okay. So 129A, very good. Because remember, tenancy by the entirety for married individuals, right? Or common law. Absolute fee simple, you know, that is the best type of fee simple to have. And then legal fee simple. That remember we reviewed absolute and legal. So when it is an estate by the court, it's a legal fee simple, right? Because they're going through the estate. If it is the owner who has the estate that they have shared with, they have conveyed to somebody else, and if they die, it goes back to the original owner, that's absolute fee simple, right? So legal means there's some court, some legality involved with it. On absolute, it's just the person has all the bundle of rights. Okay? I should say okay instead of just K. Short terminology, right? When texting, K. Okay. All right, number 30. 6 people have identical rights in a property and enjoy an indivisible interest. Indivisible. You don't divide it, okay? You get to enjoy 100% of it. So 6 people have identical rights in a property. However, any of the owners may sell or transfer his or her interest without consent of the others. So this form of ownership is what? A, joint tenancy, B, homestead ownership, C, tenancy in common, or D, estate in severalty. So remember, I'm going to give you a hint. It's not estate in severalty, right? Because that's one person. K, yeah. Just the letter K. Okay, so I've got Fabiola that says tenancy in common. Tenancy in common, the CM lifestyle. So what does that mean, the CM lifestyle? I like to have a person's name. So it is tenancy in common, right? Because 2 or more individuals that have identical rights, okay? they own the identical right. They own the they can have different percentage ownership. However, they have all the rights to own, possess, and enjoy the property. Okay, and each one can sell or convey their portion without the consent of the others. Of course, you typically will let them know. However, it's not required. Okay, because each one has their own particular ownership. So yes, that is tenancy in common. It's two or more owners. It's my fitness online business. Let's see here. I asked CM Lifestyle. It's my fitness online business, LLC, but branding real estate as well under it. Okay, got it. So, well, I went and jogged with Bailey 1.2 miles today, broke our record. And then I went to the gym with my trainer. Got to get back in shape and lose weight. We blame everything on COVID. So I blame it on COVID, but it's my own fault, right? A lot changed during COVID. Oh, so Crystal is her name. Hi, Crystal. Thank you for joining us. And yeah, so my branding, if you look at my brand, on my channel, okay, I turned my branding onto black and red. So red and black are my branding colors. So I wear a lot of black and red, as you can tell, although this looks a little bit pink, but for Hard Rock Cafe, it was supposed to be kind of red. I was a big Hard Rock Cafe person. And when I used to travel during my engineering days, everywhere I went, I would buy a baseball cap, a sweatshirt, and a t-shirt, and some buttons. All right, number 31. You get to know a little bit about me. The four unities required to create joint tenancy, okay? 4 unities, right? TTIP include which of the following conditions? A, parties must acquire respective interests at the same time. B, parties must be residents of the same state at the same time of acquiring the interest. B, C, parties must be family members. Or D, parties must have joint financial responsibility. So it has to meet 4 unities, right? TTIP. What is TTIP? Hi, Cheryl. Thanks for joining us. No, it is not B, Cheryl or Sherry. It is actually A. Parties must acquire respective interests at the same time. Okay, so what is TTIP? Type what TTIP stands for. Those are the 4 unities that are required in order for it to be the ownership to be a joint tenancy. Of course, it is 2 or more. You're missing one, Fabiola. So it is time, title, interest, and possession, not property. So time, title, interest, possession. Okay, so time, title, interest, and possession. That's what TTIP stands for. And so the difference between joint tenancy and tenancy in common, okay, I'll explain that. Oh, that's interesting. Catherine posted that on Facebook, and why isn't it showing up on here? It's supposed to be. Must be the delay in. So I have a question by Catherine, who's watching on Facebook. And the difference between joint tenancy and tenancy in common is big. Joint tenancy, it's 2 or more, okay, individuals that bought the property at the same time, took title the same way, have equal interest. If there are 4, like individuals, it's 25% each, and they have 100% possession of the property. And it has survivorship. Survivorship meaning if one of them passes away, that share goes equally to the other 3 members. Tenancy in common, it's 2 or more. They don't have to have equal ownership. Okay, they have equal possession, 100% possession, but they can have 20-80, 30-70, 40-60, 50-50, 10-90, and it does not have survivorship. They can pass that on to their heirs. Okay, and they don't need agreement to sell it with the other parties. Okay, that's the big difference. Both of them are 2 or more. Tenancy in common, I'm not sure why, Catherine, your answer is not showing up on here on. But anyway, I'm not sure what's going on. But Catherine, when you post on the Facebook group, it should show up on here. So that's the difference. Tenancy in common is 2 or more, non-survivorship, no survivorship. It goes to the heirs or whoever they want. Joint tenancy, it has survivorship, which means it goes to the other partners when they pass away, and it has to meet TTIP, time, title, interest, possession. The other one does not have to meet any conditions. They can purchase and become a partner of the property at any time. All right, number 32. Unlike tenants in common, joint tenants is what? A, owns distinct portion of the physical property. B, cannot will their interest to a party outside of the tenancy. C, may own unequal shares of the property. Or D, cannot encumber their interest to outside parties. So unlike tenants in common, joint tenants have tighter conditions, right? So what is the answer here? That is correct, Fabiola. They cannot will their interest to a party outside of the tenancy. Because it belongs to each of those individuals, okay? So the survivorship feature of joint tenancy presents an advantage over tenancy in common in that their interests pass without probate proceedings. On the other hand, joint tenants relinquish any ability to will their interests to parties outside the tenancy. So in tenancy in common, okay, they can go to probate, where in joint tenants, they don't have to. It goes to the other persons when someone passes away. So cannot will their interest to a party outside the tenancy. So they also do not have unequal shares. They have equal shares, and they cannot encumber their interest to outside parties, means they cannot get any loans or liens or anything like that outside of the 4 or 2 individuals, however many there are, being in agreement. And they don't own distinct portions of the physical property, okay? They possess 100%. They own a particular percentage, okay? However, that's the big difference, okay, between joint tenants and tenancy in common. Because in tenancy in common, they can have unequal shares. They can encumber their particular interests to outside parties, and they own distinct percentages, not portions, okay, of the physical property. So that one is not a true statement. Now, I am not understanding why. So, okay, so number 33. So which of the following life estates is created by operation of law rather than by the owner? Mentioned that a little earlier. A, conventional life estate. B, ordinary life estate. C, legal life estate. Or D, community property life estate. Very good. Everyone was paying attention, right? C, legal life estate. Very good. Awesome. What are we on? 34. Okay. Oh, man. It's not coming out. Oh. Okay, there we go. 34. 134. Which of the following is true of a homestead? Okay. A, a homestead interest can be conveyed by one spouse. B, a homestead interest cannot be passed to the children of the head of household. C, a homestead interest is a form of conventional life estate. Or D, a homestead is a primary or secondary residence occupied by family. Okay, that's another legal life estate, right? A oops. I don't want to tell you anything yet until you answer. My internet is a little bit slow, you guys. So I didn't get to show the answer for 33. Okay, so what is 34? Okay, so far I have A, and that is correct. It is A, not C. So a homestead interest cannot be conveyed by one spouse, right? Because they have equal ownership in a homestead. A homestead is for if they're married, right? Let's see. Tenants by the entirety, that's for married individuals and they have survivorship. So if one of them dies, it goes to the spouse, not to the heirs. So one spouse can't convey theirs without the permission and the agreement of the other spouse. Now, secondly, what I was going to say is that a homestead interest is a form of legal life estate because it is provided by the state. Okay, so in the other question where I mentioned legal life estate, so a homestead is a type of legal life estate. It's not a, let's see, it's not a, how is it? It's not an absolute life estate, okay? It is a legal life estate. The other one is per the owner. Here, they're protected by the state. If it's their primary residence, they own it, then homestead allows them to have one homestead in the whole United States. You can only claim one property as a homestead. So it's a national law. And it protects the individuals from creditors like credit cards. Okay. So David mentioned C, a homestead interest is a form of conventional life estate. No, it's actually a legal life estate because it's a state law. Not all states have homestead. So I can't tell you if 50%, 30%, or how many have them. I haven't researched that part. But there are many states. I was in Oregon. We had homestead. I'm in Texas. We have a homestead. So if you're in other states, look up and see if you have a homestead because you will get a financial exemption, okay, on your property taxes. And you want to make sure you claim it. You automatically get homestead. However, you won't get the reduction in property taxes, okay, unless you go and file a piece of paper at the county tax assessor. All right. Number 35. A tenant in common can do what? A, sell or transfer in their interest without the consent of the other tenants in common. B, use his or her interest in the estate to encumber the entire estate. C, sell, encumber, or transfer his or her interest only to the other tenants in common. Or D, sell, encumber, or transfer his or her interest only with the consent of all of the other tenants in common. So remember, they own a property, two or more own a property. So what does a tenant in common? And they don't have survivorship, right? They can will it to their heirs. So the answer here is A, they can sell or transfer their interest without the consent of the other tenants in common. So I have bought property when I was investing from other individuals that had a tenant in common type of ownership. And so I only bought the share of one person. The other person still stays the same. So now I became a tenant in common with the existing owner. And that existing owner didn't have to agree, okay, or disagree with that one other owner to sell or convey it. That's a difference with tenants in common versus tenants joint tenancy. All right, number 36. Which of the following would be considered community property? Okay, there's only 9 states that have community property. A, property acquired before marriage. B, a motorcycle bought after the marriage with separate property funds. C, income derived from community property. Or D, a mother's heirloom wedding ring gifted to the wife after the wedding. Type your answer in the chatty chat. Yes, Fabiola, the answer is C. It is income derived from community property. If it was earned, if the community property was purchased prior, okay, to marriage, then it is not community property, right? However, the income received from that property during the marriage, that is considered community property. Unless it's under an LLC and the spouse is not under the LLC and none of the monies from the LLC are commingled with the marriage, okay? Then any rental, any expenses would be from the LLC, from the investment, and then go back to the investment. So income derived from community property is considered community property. And it doesn't have to be property that was purchased during the marriage, right? One of them could have purchased it prior to the marriage, and then they're now married, and it's a rental, and they're getting income. That is community. It belongs to both. When real property is held in a land trust, who controls the property? A, the trustor. B, the trustee. C, the beneficiary. Or D, the mortgagee. So the ORs and EEs. So in a land trust, this is not a land contract. In a land trust, who controls the property? Who actually owns the property in a land trust? No, it is not A, because the trustor could be an LLC. Okay. And then the trustee is someone that they trust to follow the directions of the beneficiary. Okay, so the beneficiary is actually the owner of the property, of the land trust. So this is a form of multi-level asset protection, is to put them in a land trust, have an LLC, and the beneficiary is actually like me or you, but nobody knows that unless they pay attorneys a lot of money to go research it and find everything. Okay, so the trustee doesn't control it. The trustee follows the instructions of the beneficiary. And the trustor, okay, sometimes the trustor and the beneficiary could be the same in a land trust. However, typically investors do not do that. Okay, so the trustor could be the LLC, a business corporation, a business, entity, and the trustee is a family member or somebody else with a different name, so that there's nothing that triggers that this person with the same last name owns the property, and the beneficiary is the actual person that owns it. The actual beneficiary owns the LLC and also owns the land trust. Okay, so Fabiola has a question. Okay, and the trustee holds title. Yes. And so similar to a deed of trust, okay? So the trustee has the right, under the instructions of the beneficiary, okay, or the trustor, right, to pursue certain events. Like, let's say they want to sell it, so they ask the trustee to put it on the market. So it's similar to a trustee in a deed of trust. When a bank is the bank is the beneficiary, okay, the trustor is the borrower in that case, when you have a mortgage. And so the trustee could be an attorney, it could be someone else, another mortgage servicing company that proceeds with following the directions of the deed of trust in case there's a borrower that defaults. Then they go by the deed of trust to pursue with, what do they call it? Accelerate the note, okay, and start a foreclosure. Or send them notice and say, hey, you need to catch up with your payment. You have another 30 days. If not, we will start the, I was going to say divorce proceedings, the foreclosure proceedings. Okay. So good question, Fabiola, or good comment. All right. So most of you answered A, B. Yeah. So A, the trustor in this case could be the, when there's a land trust, it could be the LLC. That's typically when you have land trust, you want to protect different properties that you own, so that if somebody is sue happy and they want to sue you, they're not going to find out who the beneficiary, who the owner really is. So the owner doesn't really own anything. They own the LLC, but they don't own the real estate. And you're going to say, well, that's kind of weird. They really own the real estate. Well, according to legalities, okay, they don't. The LLC owns the property, okay, and that's an asset protection process in order to protect their interest in different properties. Because a sue happy person could start suing them, a tenant or somebody else, and they could lose a lot. So when you go to attorneys, they'll recommend, okay, do an LLC or a subcorporation, and then have land trust. And the land trust can be named after the address of the property, so that they can distinguish each different land trust. All right, number 38. So that's getting more into it. So if you ever get into investing, you'll learn about that. 138, in a community property state, okay, community property state. Again, there's only 9 in the US. John marries Patricia. However, it's a national question. Prior to the marriage, John owned an SUV. During the marriage, John bought a Buick John and Patricia bought a second property with money earned from Patricia's job, and each individual received a motorcycle from Patricia's uncle as a gift. Okay, what property is community property in this marriage? Okay, so prior to marriage, John owned an SUV. During the marriage, John bought a Buick. John and Patricia bought a second property with money earned from Patricia's job. Okay, however, that's money coming in during the marriage, and each individual received a gift of a motorcycle. So which of those items are considered community property? A, the SUV, the Buick, and the second property. B, the SUV, the Buick, the second property, and the motorcycles. B, the Buick and the second property. Or D, the Buick, the second property, and the motorcycles. Very good. Good afternoon, Allah, or good evening. Thank you for joining us. We are doing national questions that apply to all 50 states. Yes, the answer is C. The Buick and the second property. Why? Because they were purchased during the marriage. Now, you know, if only one of them is employed, it's still community money coming in, right? Because one of them is employed or both are employed, money belongs to both. The 138 is C. Very good. All right. $139. Which of the following is true of a cooperative? A cooperative may hold an owner liable for the unpaid operating expenses of other tenants. B, the owners have a fee simple interest in the airspace of their respective apartments. C, owners may sublease their apartments even if they sell their stock in the cooperative. Or D, the proprietary lease is guaranteed to have a fixed rate of rent over the life of the lease term. So a cooperative, what is a cooperative? So type your answer in the chatty chat. Okay, so far, let's see, I've got D and B. Okay, cooperative, the answer is actually A. And I'll actually read the answers to you. So a cooperative may hold an owner liable for the unpaid operating expenses of other tenants. Okay, so the cooperative, okay, is a type of residential option, housing option, actually a corporation that is owned by a corporation whereby the owners do not own their units outright. So that is a co-op. And instead, each resident is a shareholder in the corporation based in the part of the relative size of the unit that they live in. So the answer in the book says, since the corporation owns an undivided interest in the cooperative property, debts and financial obligations apply to the property as a whole, not to individual units as in a condominium. Okay, so this could be like maybe a timeshare. So the answer is A. They don't actually own the unit, okay? They own possession of it for a certain period of time. So let's see, B had D and B. B says the owners have a fee simple interest in the airspace. No, they do not, because it is not a condominium. Okay, it's a cooperative. So, and then D, the proprietary lease is guaranteed to have a fixed rate over the life of the lease term. No, that can change. They have, you know, maintenance fees and such. So go back and review cooperative. Now, some cooperatives become, condominiums, but they have to go through major changes, legalities and stuff to do that. And some apartment complexes can become condominiums and sell each unit. That's why sometimes condos are called apartments. Okay. At one time they could have been apartments, and other times they were developed as condominiums from the start. So in the condominium, they own the airspace inside the condominium and share the outside by paying HOA dues. Okay, for maintenance of the outside, gated communities, and the outside of the building. The insurance covers the inside, the airspace inside the unit, or, also known as apartment. All right, number 40. Which of the following is true of a tenancy in common? Another tenancy in common. A, the co-owners must be related. B, the owners enjoy an indivisible interest. C, the tenants must acquire their interest at the same time. Or D, the tenants must pay equal amounts for their interest in the estate. Remember, tenancy in common, it is two or more, but it's different than joint tenancy. They have possession of the entire property, enjoyment of the entire property, right? Not just the percentage that they own. Okay, so far I have B and B. Yes, that is correct. B, the owners enjoy an indivisible interest. They could own different percentage, okay? However, they enjoy 100%, okay, of the property, indivisible interest. You don't share just half of the house. You enjoy the whole house, okay? But you have different percentage ownership. You could have equal percentage ownerships. But they didn't have to buy it at the same time. They don't have to be related. And it's not that they pay equal amounts for their interest. Okay. All right, what was that? All right. So we've done 15 for national. We can continue on. We've almost been on here an hour. So you guys can tell me, anybody watching the replay, you can just fast forward while my live students make a decision and let me know if they want to have a few more national questions or proceed on to Texas state questions. So type on the chat. So thanks for joining us. I'm Winston. Let's continue, please. Okay, who else? There's quite a few on you here. So in the moment that you're deciding, if you haven't been to my YouTube channel, YouTube Agent Prep, hey, please go and visit YouTube Agent Prep, okay? And subscribe to my channel, click the thumbs up and send me some love. And of course, click that little bell and be the first to be notified, okay, whenever I go live. And this is Wow Lily Handy with YouTube Agent Prep, coming to you from San Antonio, Texas. And I'm also a realtor with Exp Realty. I'm an active realtor, so I am looking for individuals to evaluate EXP and maybe decide to join us or not. Okay, so let's see. I only have one person stating continue with national. So those staying state, then we proceed with state. Okay. So I have 3 individuals specifying state questions. Does anybody else want to vote on state or national? Type it in the chat real quick so that I can proceed. If no more comments, we will continue with state questions. And again, anybody watching the replay, please just fast forward, because now I have to change gears and go to the state section. Hi, Miss Stacy. Thanks for joining us. And we're going to number 13. So, you know, for those of you that are here, I've heard that the national exam or the state exam can be much harder than the national. And you know what? It depends on the person. I've heard it both ways. Okay, where the state, of course, you do have to know a lot of law, and that can make it more difficult than the national. All right, so here we're going to do for state. Okay, we're going to do section 13, which has to do with standards of conduct in brokerage or practice. So the prior video that I did on Monday, okay, went over, go back to that one, and that one went over licensing regulation and Texas Real Estate Commission. And it is on this book, okay, Texas Real Estate License Exam Prep by Stephen Medling and 3 other authors. And I actually spoke with them, and it's awesome. And we're in agreement about using their books on here. So not violating copyrights. They're excellent books. I really like these books, and so do other students. Okie dokie, here we go. So standards of conduct and brokerage practice. So you can watch the replay of number 1, okay? And you'll be able to see what we covered. And so I will continue with this book for the national and the state. All right, number 13.1. Licenses must conspicuously display Form 1-1, a consumer disclosure form. Its central message is to do what? A, license should abide by the rule, caveat emptor, okay, buyer beware, or let the buyer beware, right? I woke up dreaming about this. Vocabulary, vocabulary, vocabulary. B, licensees do not necessarily represent the party who compensates them. C, TREC maintains a recovery fund that may be used to satisfy judgments against licensees who have violated the law. D, licensees are not bound by any duty to maintain confidentiality in their dealings with customers and clients. So what is Form 1-1 by TREC that we have to disclose on our email and the signature and social media and such? Letting the public beware. So the answer here, nobody? The answer is 13.1 C. TREC maintains a recovery fund that may be used to satisfy judgments against licensees who have violated the law. So it allows individuals to complain against licensees who are not practicing real estate ethically. Nobody answered to that one. Wow. All right, number 2, 13.2. And it is 13.2 because it's test 13 in that book. Okay, there we go. All right, unbeknownst to a buyer, an intermediary informs a seller. So what is an intermediary? Remember, we're Texas questions. intermediary informs the seller that the buyer will pay a premium price for the seller's property. Is this an acceptable disclosure? A, yes, since the intermediary represents the seller, he is acting in his best interest. B, yes, since the common knowledge that the buyer is on a very tight deadline to move in. C, no, since the intermediary did not receive the buyer's authorization to make such a disclosure. Or D, no, since the disclosure violates the agency's fiduciary duty to the buyer. So unbeknownst to a buyer, an intermediary informs a seller that the buyer will pay a premium price for the seller's property. So first of all, is it acceptable or not? So we know that it is not. So it's either answer C or D. So the answer here is actually C. Everybody answered D. Hi, Yesenia. Thank you for joining us. Okay, so the answer is C. No, since the intermediary did not receive the buyer's authorization to make such a disclosure. Okay, so it says intermediaries are bound by law to treat transaction principles fairly and honestly. The price disclosure specifically violates rules of conduct for intermediaries. Further, intermediaries are not bound by fiduciary duty to a single transaction principle, since he or she effectively represents both parties, right? Even though we're not a dual agency state, the broker, when represents both sides, one by a seller agent and another one by a buyer agent, then they represent both. And they don't have a fiduciary duty just to one, they have it to both, right? And so they have to have permission from both in the listing contract and in the buyer's contract to act as an intermediary. And we cannot be disclosing that type of a comment that the buyer will pay a premium price for the seller's property. Okay? Yes, that is a tricky one. So the price disclosure specifically violates rules of conduct for intermediaries and also for realtors, right? The buyer agent and the listing agent. And so intermediaries are not bound by fiduciary, right? Because they don't directly represent one person, right? They represent both in a single transaction. Okay. Therefore, they effectively represent both, not just one. Yeah, that was a tricky one. But we knew the answer was no, right? Because we don't disclose it unless we have the actual permission, written permission of the buyer. But our job as representing a buyer as an individual, okay, an individual principal, is to get the highest, the best price for the buyer, the lowest and best price and terms for the buyer. When we represent a seller, it's for us to get the highest and best price for our seller with the least conditions, right? So it depends which hat you're wearing, buyer hat or seller hat. When I represent a buyer, I help them ask for everything if it's doable and they're not competing for anything. When I represent the seller, my job is to attract ready, willing, and able buyers that bring us the highest and best offer. Okay, with the terms to be real easy. Number 3, a licensee who is charged with felony fraud pleads no lo contendere, and all charges are dismissed. In this case, the licensee is what? A, may have his license suspended or revoked. B, must notify the real estate commission of the guilty plea. C, is exempted from any commission notification since there was no guilty plea. Or D, has done nothing wrong. So licensee is charged with felony fraud and pleads, not guilty, no lo contendere, on all charges, and all charges are dismissed. So do we still have to inform TREC or not? Okay, so far I have A. Yes, the licensee may have their license suspended or revoked. So key, it may. Doesn't mean they will, but they may. And we also do notify TREC, okay, of any guilty plea. So a licensee who is charged with felony pleads no contender and all charges are dismissed. However, the licensee does have to notify TREC and their license could be suspended or revoked. So B is also correct, but it's not the best answer. They're not exempt from any commission notification and they have done something wrong. Okay. So sometimes there could be more than one correct answer. However, we have to select the best correct answer that has the best impact, the most impact. Oh, I need to type the answer. All right, number 4. A licensee opts to use a custom design form to transact a residential sale. Okay, so the licensee says, oh, I want to use a custom design form to transact a residential sale. The contract used was a bona fide sales agreement used extensively prior to the existence of TREC promulgated forms. In this case, the licensee is what? A, faces legal exposure for the unauthorized practice of law. B, could have her license suspended or revoked, his or her license. C, may supplant a promulgated form with a previously used contract with impunity. Or D, has not committed any violation of license law. Yes, it is B, could have their license suspended or revoked, because promulgated contracts are created in order for us to use those contracts. So TREC requires us to use those contracts unless a client goes to an attorney and the attorney writes the contract for them. Attorneys can write contracts. However, when we're representing a client and we're selecting the documents, we use TREC promulgated contract. That's why we take a whole 30 hours of promulgated contracts course, right? So could have her license, his or her license suspended or revoked. All right, very good. So let's see. Fabiola says was incorrect because it said guilty plea. Oh, on the prior one. Yes, it was a guilty. Oh, that's right. It was a guilty plea. Correct, Fabiola. They actually said no contended, but they were charged. The fact on number 3, yeah, it wasn't that they did a guilty plea. They were charged with felony. So anytime we're charged with felony or not, we have to inform TREC, even though the charges were removed. And TREC may review the situation and then decide whether to revoke or suspend. So thank you for that, Fabiola. So 13.4 was also B. Could have her license suspended or revoked. And so it says it's not acceptable you use forms other than promulgated forms in such instances where they are mandated. And that's why we take a whole 30 hours of promulgated contracts, because they are mandated for us to use them. Okay, number 5. Which of the following is a license law violation? A, failing to retrain trust fund records for the required 6 years. B, advertising listings without an advertising license. C, failing to recommend that a buyer obtain an inspection or a transaction. Or D, failing to disclose a previous licensed tenancy from another state on the license application. So which one is a license law violation? Thank you, Fabiola. I got it. Okay, so the answer here is D, failing to disclose a previous licensed tenancy from another state on the license application. So when we apply for a Texas license, it does ask us whether we've had a license in another state or we have a license in another state currently or not. Right? So the answer says failing to disclose a previous licensed tenancy from another state on the license application. It is illegal to try to obtain a license by negligent or intentional misrepresentation on the application. By contrast, it is not legal to not recommend an inspection. The trust fund retention requirement is 4 years. Okay, so there's a statute of limitation for anybody who wants to complain, right? So we keep records for 4 years, not 6. And advertising does not require a separate license, right? That's why we do marketing and advertising. All right, Nora, and then that permission is given to us in the contract and the listing agreement when we have with the seller. Okay. Number 6. A sales agent is interested in selling a duplex they own that is not making enough money. In fact, the units are in the red with no end in sight. Which of the following is true? So why would somebody buy a duplex that's not making money? A, the license is barred. The licensee is barred from personally selling the property since he is licensed. Oh, I'm sorry. They're interested in selling a duplex. B, the sales agent may sell the property provided they disclose the loss in the pro forma profit projection. C, the licensee may sell the property without restrictions regardless of the profitability. Or D, the sales agent may sell the property provided they make proper disclosure as to being a licensed status. No, it is not. It is not B. Okay, you don't have to show the pro forma profit projection if they don't have it. If it doesn't, then the investor won't buy it. Okay, and the thing that is the best answer here is the sales agent may sell the property. Okay, but we have to disclose that we are a licensed realtor, right? Because we're not the normal home seller, duplex seller. We're an investor, a la. But we can sell any property that we want. It doesn't have to be profiting or not. And if the buyer asks for a rent roll, then we provide and we say, hey, we're not profiting. However, that investor might want to buy it for depreciation purposes, or that they can remodel it or improve it to start making money. And let's see, the licensee may sell the property without restrictions, regardless of the profitability. So the restriction is we have to advertise and disclose that we have a license. We do have that restriction. Okay. All right, number 7. 3 of the following statements constitute a violation of acceptable brokerage practice, and 1 statement represents acceptable practice, which is not a violation. So which one is not a violation of brokerage practice? A, sales agent tells a buyer that the seller can paint the house in 2 days, a job that takes 4 days. B, a sales agent places a new sign on a property advertising a reduced price despite the fact that the listing expires in less than a week. C, broker uses $500 from their trust fund to pay a personal fee and redeposits the money back into the account within 24 hours. Or D, a sales agent tells a buyer that he guarantees the property will appreciate as it has for the last 10 years. Whoa, man. They got a crystal ball, right? So which one can we do? Which one is not a violation? Our goal is to sell it till the last minute, help the buyer, help the seller sell the property. We actually don't sell it. We attract buyer, ready, willing, and able buyers to this for the seller, right? And we can keep reducing the price until we trigger an offer, just before it expires. So the answer is B. A sales agent places a new sign on a property advertising a reduced price, despite the fact that the listing expires in less than a week. That's okay. We might get an offer in that less than a week, because price reductions can eventually trigger an offer. Okay, number 8. Which of the following statements would subject a licensee's license to suspension or revocation? A, including the broker's business identification on an advertisement. B, receiving a 10% commission on a property sale when the going rate is 6%. C, placing an excess number of signs on a property for sale. Or D, persuading a represented seller to hold off on selling until the listing period ends, at which time the sales agent can get her a much better price. So which one is a reason for suspension or revocation? All right, so far I've got answer D. So remember, oops. Well, Yesenia, you typed the question number and left out the letter answer. So, so the answer here is D. Right? Persuading a represented seller to hold off on selling until the listing period ends, at which time the sales agents can get her a much better price. No. Okay. The listing can expire, okay, but not hold off on selling it. Our job is to bring the highest and best offer from a ready, willing, and able buyer. And that buyer could come from other realtors or could come from our marketing signs or marketing advertising anywhere. So, and the reason being here, according to the answer, it says it is illegal for licensees to interfere with active listings and represented buyers and sellers. Okay, we cannot use like our personal opinion. By contrast, a 10% commission is perfectly legal, as is numerous signs on a property. The broker ID on advertisement is in fact required. Okay, so we can't steer a client, all right? It's their decision. Okay, so Miss Stacy says, I went and took my national and state today, and I failed national by 4 points and failed my state by 1 point. Oh, I ran out of time on my national, couldn't go back and do the 4 I had flagged. Oh, I'm sorry. So the reason why we ask you to go back and, flag, some questions is so that you can go through it a little bit easier on the easier question. But don't feel bad. That happened to me in Oregon and in Michigan. Okay. In Texas, I didn't have to take the national because I already had an Oregon license. So when I did my 180 hours, I only had to take the state exam. Lucky me, right? But whenever I took the, so sorry to hear that. Okay. However, hey, you did great. You missed the national only by 4 points and missed the state by, and failed my state by 1 point. I know it hurts a lot when you only miss it by 1 point, Miss Stacy. That just says either you got really nervous on the exam and you ran out of time on the national, and or you need to go back and review and study again. So that's okay. Don't punish yourself. Don't be so hard on yourself. I know I used to be really hard on myself. I would cry, I would throw up, okay? Because I hated failing, but it's not failing. It's just letting us know that we need to study a little bit different, need to study more and review the material and the vocabulary. Okay, so that was number 8, 13.8D. All right, number 9. So thank you, Stacy, for sharing with us. It is important for others to see and to hear, just like individuals that repeatedly let me know and tell everybody else. Study that vocabulary. It is crucial. Okay? You don't have to, remember them all afterwards, but hey, remember them now for the test. And try to take your test as soon as possible, that you can reschedule it. And review the material, the sections that you also missed. And in the comments below, one of the books that I use is the Texas Real Estate Sales Exam 4th edition from 2006. That book is excellent because at the end of each, it has 4 exams. And at the end of each exam, after the answers, it has a breakdown, of the scores of all the questions and what category the questions pertain to. And then you can review those particular questions that pertain to either, contracts, to agency and brokerage or conduct. You can review, it'll tell you which questions on the 110 questions for 80 national and 30 state pertain to your area that you were weak on. And that's what I mentioned to Cindy earlier today, is to go back to that book. Now, I don't have a link on there. It's actually a free book online, Texas Real Estate Sales Exam 4th edition, by Learning Express. Just be very careful if you're going to download. There's a lot of websites that are saying, hey, download here. And when you click the link, it ends up downloading or taking you somewhere else. It's also on my Facebook group. Okay, on my Facebook group, Real Estate Exam Prep group with Wow Lily Handy, Agent Prep. That's our private group. It's in there. It's under one of the guides. I think it's guide number 3. You can go in there and click the post that I get under the guides and download it. Okay, so Yesenia also says, I also failed my national by 3 and Texas by 2. Yesenia, thank you so much for sharing. And you guys, don't be, ladies and gentlemen, don't be afraid of sharing what happened to you, okay? Because you're not a failure. We're not a failure when we don't pass. It just tells us we have to go back and study some more, okay, until we pass. And don't think it's, oh man, it wasn't meant to be. Okay, I wasn't supposed to be a realtor. However, if you realize that maybe this isn't what you want to do, but sometimes you won't know until you start practicing real estate. So don't give up. Keep going. Keep at it. Some of my students took it 5, 6 times, 8 times, 10 times, and finally passed, and they are successful realtors at this day. They learned the material better. You're really going to learn the real estate business when you're actually doing the business. All right, number 9. 3 of the following are license law violations and 1 is not. Which one is not a violation? Okay, so 3 are violation, 1 of them is not. A licensee forgets to mail a copy of signed transaction document to a principal. B, a broker distributes funds during a closing. C, a broker makes 1 monthly deposit into the trust fund on the first business day of every month. Or D, informs a prospective buyer that a property might still be for sale even though the sale has closed. So which one is not a violation? That one is number 9. Yes, okay. So although funds, okay, are in escrow at a title company or at the attorney, sometimes in some areas, they could end up having them in their trust fund. No, it's not. We are required to give our clients a copy of the signed transaction documents to a principal. However, that is not a violation. Okay, we can end up sending it. We are supposed to provide them with a copy. I mean, that is a violation. Sorry. So, because we do have to give our clients a copy. The one that is not a violation is a broker distributes trust funds during a closing. That's when trust funds, escrow money, any types of funds. Some real estate companies have a trust account and they may keep deposits or whatever for a client in there and then send it to the title company at closing. So as long as they're in a trust fund that are not commingled with personal business funds, okay, then it is not a violation. So the first one said, a licensee forgets to mail a copy. Yes, that is a violation. Nowadays, everything, so much is done online. So the clients have access to the document already that they've signed and we've emailed. Sometimes they'll ask us to mail a hard copy. C, a broker makes one monthly deposit in a trust fund on the first business day of every month. It's just, that is not a violation, right? So which one is not a violation? That could be a violation because it depends what kind of trust fund they've got, all right? And D, informs a prospective buyer that a property might still be for sale even though the sale is closed. That is a violation. Okay, so once a property has closed, we can't tell them it's still for sale. So Yesenia answered D. And let's see, David answered A. A licensee forgets to mail a copy of a signed transaction document to the principal. Clients have to have a copy, okay, of all transactions so that they can review them in more detail at their time, or they can take them to an attorney and they have a copy so they know what they sign, because a lot of people will sign documents and don't read the detail. So the one that is not a violation is a broker distributes trust funds during a closing. So let's see what it says here. Closing is in fact the proper occasion to distribute trust funds. However, licensees must provide principals with transaction document. They must deposit trust funds in a timely fashion. Oh, that's why that one is wrong. It says a broker makes one monthly deposit into the trust fund. As soon as we get monies, and if they have a trust fund, must be deposited there. And then last, it says they must deposit trust funds in a timely fashion following receipt, and they cannot misrepresent or deceive the public. That's on D. So D is misrepresenting or misleading the public. So trust funds, whether it was a broker, escrow company, or the attorney or the title company, they get distributed during closing. Okay, that's when trust funds are distributed, or in the escrow account. All right, number 10. Did you all get that? And thank you all for participating. And there's a whole bunch of you on here. And if you're not participating, I highly recommend that you participate by typing the question and the question number and the answer, because this is an interactive class where I can explain the answers if you get them incorrect, and let you know it's okay to make a mistake on here, right? It's better to make the mistake on here than on the actual exam. All right, number 10. Which of the following constitutes the unauthorized practice of law? A, advising a seller that her property has a title defect. B, completes a tract promulgated contract. C, informing a buyer that a property purchase entails numerous legal ramifications. Or D, advising a seller to obtain sufficient property insurance. Which one is an unauthorized practice of law? Come on, type your answer on the chatty chat. The answer is A. Advising a seller that their property has a title defect. We are not attorneys. Those are done by the title company, or they go to an attorney to get that. Using a promulgated contract, okay, that's okay. Informing a buyer that a property purchase entailed numerous legal ramifications. Yeah, it states it on the contract. And D, advising a seller to obtain sufficient property insurance. Yes, we can do that. That is not unauthorized practice of law, because the lender is going to ask them to, if they have a loan, the lender is going to require that they get property insurance. So it's okay for us to recommend, 3 insurance companies and let them choose, the best that is for them. So number 11, which in the following constitutes practicing law without a license? A license completing lease blanks in a lease that was written by an attorney. B, an agent completing a promulgated contract. C, a licensee completing the blanks in a contract prepared by a principal. Or D, a licensee altering a lease clause at the direction of a principal. So which one constitutes practicing law without a license? And actually, we don't practice law at all, right? But without a license, it's even worse. Actually, it's not A. We are allowed to, what actually we do is fill in the blanks, okay, on contracts and leases. Okay, we do that. A licensee completing lease blanks in a lease that was written by an attorney, okay? And that's practicing law without a law license, okay? B, an agent completing a promulgated contract. Yes, we complete the fill in the blanks on the instructions of our principal. C, a licensee completing the blanks of a contract prepared by the principal. Yes, we fill in the blanks. We ask them questions and we fill in the blanks. And D, a licensee altering a lease clause. Okay, that is practicing law. It's altering a lease clause. That is changing a legal contract. So the alteration of a lease clause requires the creation of a legal contract clause, which requires an attorney license. So when they mention here without a license, it doesn't mean a realtor license or a broker license. They're talking about an attorney's license. Okay, because only attorneys can modify contracts. Okay, so then licensees in Texas are essentially limited to form completion activity. We fill in the blanks according to the instructions of our clients, our principal, whether a client's contract or an attorney's contract. Okay, so 11 D. Right, so let's see. Some of you answered, David answered A and C. So no, we fill in the blanks and we fill in the blanks. So A and C talk about filling in the blanks. Yes, we do that. That is what we do. We don't change clauses. We don't add anything that we want to our opinion. We go by the instruction of our client and fill in the blanks. So 13D. Y'all get that? So altering a lease clause, we cannot do that. We cannot scratch anything out. We cannot edit a clause. Only that can be done by an attorney. And if the principal does it, they have to initial it. Okay, and then we have to deal whether the title company or the escrow officer is going to accept it. Okay, good for letting me know, David, that you understand that. Okay, number 12. Which of the following best characterizes trust funds? A tenant security deposit. B, a rent check paid to a landlord. C, an unearned fee charged to a tenant, or D, any money held on behalf of another. So which of the following best characterizes trust funds? Type your answer in the chatty chat. Awesome. Very good. I'm Winston, David, and Crystal, and Allah. Oh, no. Allah, you said A. A tenant security deposit, that characterizes depositing it into a trust fund. Okay. So that is. So it's any transaction, any money held on behalf of another goes into a trust account. Okay. It's considered trust funds. The key word is on behalf of another. So security deposits, okay, rent amounts, pet deposits, last month's rent check paid to a landlord. Yes, that can go into a trust fund and they distribute it to the landlord according to how they want it. And under a fee charged to a tenant, yes. So understand. Awesome. Very good. Okay, good. All right, number 13. When a home buyer gives a broker an earnest money deposit, the broker is bound to do what? A, return all funds upon request. B, comply with fiduciary duties owed the seller. C, abide by the terms of the sales contract. Or D, immediately deliver the funds to the seller for depositing. Ooh. What are we on? Number 13, right? Yes. Type your answer in the chatty chat. Oh, no, it is not D. We do not deliver earnest money to a client, a principal, unless it's agreed upon between the seller and the buyer. And the buyer says, hey, release the money to the seller. But no, it is not that. It's deposited into escrow. Okay. When a home buyer gives a broker an earnest money deposit, the broker is bound to do what? No, it's not. We go by the instructions of the contract. Abide by the terms of the contract. The contract states what to do with the earnest money, and it says to be delivered into an escrow account within 3 days. Okay, 3 business days, or 3 days, pardon me. So it goes to the escrow account, which could be with a title company, or it could be an escrow officer that is an attorney. So the contract states what happens to that money, and within so many days. So let's see. And you answered B, comply with fiduciary duties owed to the seller. Well, the fiduciary duties to our seller, is not here. It's where fiduciary duties are to a home buyer. Because it says when a home buyer gives a broker an earnest money deposit. So the fiduciary duties are to the buyer is to deposit that money with an escrow account. Okay. So yes, sometimes we hold on to it until the contract is signed by both parties. When we get an earnest money, we get that when the buyer signs a contract, or we get a copy of it so that we can share it to the listing agent to be presented to the seller. Okay. And as soon as the contract is executed, okay, that is the date where everyone has signed, initialed, and has been informed. Okay. Then, because remember, it has to be informed, delivered, okay, and announced to the other party, because the other party could cancel prior to being informed. And therefore that money is held until that is executed, and then it's delivered to the title company. It's wired directly by a client to the title company. During COVID, a lot of other activities happened where they could wire directly or do another direct deposit. So new options came about during COVID. Before, it was deliver a personal check or a cashier's check or a money order. Now they allow wiring, and there's also title companies apps that can allow them to quickly transfer the money. So 1313. Which one was I? Oh, see, abide by the terms of the sales contract. So let's see. So the broker must deposit in a trust account and hold in accordance to the terms of the buyer's sales contract with the seller. Additional state laws apply to withdrawing funds when the dispute are involved. Note that the broker cannot simply comply with the desires of a buyer or seller to receive these funds, since the funds do not technically belong to either party until the transaction has been consummated or terminated. And if the contract is terminated, then addendum to terminate, okay, an amendment to terminate has to be presented, and a release of earnest money, and both parties have to sign the release of earnest money. Okay, very good, Stacy. So 13C. All right, number 14. Let's see, Winston. See, abide by terms of the contract. Learned. Okay, very good, Winston. All right, number 14. A sales agent receives a security deposit on a lease, okay? Sales agent receives security deposit on a lease. What is this sales agent's proper course of action? A, deposit the funds immediately in her trust account. B, deposit the funds within 3 business days of receipt of the deposit. C, deposit the funds in the operating account immediately. Or D, deliver the funds to the sales agent's broker for depositing. So as sales agents, okay, what do we do with any deposit monies that we receive? And the best thing is not to receive any cash, right? Receive cash, money order, cashier's checks. Okay, let's see. I've got A, B. Okay, I have a variety of answers. Okay, the actual answer is D. Deliver the funds to the sales agent's broker for depositing. Okay, so the broker could have the trust fund, and we deposit it in there. So that's what we do with the deposit. And any monies that we receive, okay, on a rental lease, then that is provided to the brokerage. The first month's rent, of course, the tenant is going to pay the seller, the landlord. But the deposit, which is what we get paid our commission from, okay, that will go to the broker. And then the broker distributes the commission according to the commission split. Okay. Well, okay, Stacy, come back to retake on September. I'm going back to retake on September 7th. Okay. On Labor Day? Forget what day is Labor Day. So 14 was D. Deposit the funds to the sales agent's broker for depositing. What? Depositing into the brokerage trust funds. So when the brokers receive commission from other brokers, it goes into a trust fund. And then from there, we get paid. Or if there's a referral, that's where the brokerage pays the other brokerage, and that brokerage pays their sales agents. Okay. So Stacy is taking her exam on the 7th. Very good, Stacy. That gives you a couple of weeks to do some more studying. Awesome. All right, number 15. Hi, Marcella. For some reason, you're showing up as Facebook user, Marcella. If you could go to StreamYard.com/Facebook and give StreamYard permission to post your name on here, then you'll be able to see it like Miss Stacy or Yesenia or, AgentPrep. Okay. So we all have to give StreamYard permission to post our name, and you can do it really quick. You just go to that link right there and .com/Facebook, and it's a really quick step. All right. Number 15, as a newly licensed broker, you receive a buyer's earnest money deposit on Tuesday morning. When is your deadline for depositing the check into your trust account? A, Wednesday morning, B, Wednesday night, C, Thursday night, or D, Friday night. So newly licensed broker, you receive earnest money deposit on Tuesday morning. When is your deadline for depositing this check into your trust account? So this is for, the brokerage trust account, okay? Not to the title company according to the contract. Two different things. No, the answer is actually C. Okay, so according to the book's answer, it says Thursday night. And why is that? Because you have 2 working days following the receipt of those funds. And so that's put into the broker's trust fund. Okay, so this is different than doing what the contract says. So as a newly licensed broker, you receive a buyer's earnest money deposit on Tuesday morning. When is your deadline for depositing this check into your trust account? So the broker has a trust account. Okay, they're not sending it to escrow yet because it's not a consummated or it's not an executed contract. So they have 2 business days. So business day 1 would be 24 hours later, which is Wednesday, and it usually ends by 5 o'clock. And then second business day would be Thursday, 2 days later. So you always count 24 hours later. So Tuesday, 24 hours later, and Thursday, 24 hours later. Okay. On the contract, it says deposit earnest money to the escrow company after the contract's been executed within 3 days. But this has to do with the broker's trust fund. Even though it doesn't say there, yes, into the trust fund, okay? All right. We're going to do about 20 questions, okay? And then we should end by 8 o'clock. All right, number 16. The Jordans and the Couriers have jointly directed the broker Michael in writing to pay out in writing. Okay, so he's instructed them on writing, paper and ink or pencil, to pay out, not pencil, ink, to pay out the earnest money deposit to the Courier's son. Okay, so Jordans and the Couriers have agreed to, jointly directed the broker in writing to pay out the earnest money deposit to the Courier's son, Stephen, despite the fact that this action is not stated as a permitted disbursement in the sales contract. Michael refuses to disperse. Which of the following is correct? A, Michael must disburse the funds as directed. B, Michael must follow the provisions of the sales contract and refuse the directive. C, the principals have made an improper request and the matter must go to arbitration. Or D, the matter must be remanded to the registry of a court for settlement. Okay, so I mentioned something a little bit, I think 1 or 2 questions back, about what can happen to earnest money if we have permission in writing or are directed in writing. This is number 16. So type your answer in the chat. I have to say, I admire all of you, and I'm so impressed that by watching and just listening, you can answer questions. If you can answer them this quick, you should do good on your exams, okay? In addition to knowing the material. Okay, the actual answer, yes, you might think we have to follow what the contract says. However, they probably had an exhibit attached to the contract that stated seller and buyer agree, and buyer directs the broker to release that earnest money to the seller. Okay, so it says Jordans and Couriers have jointly, okay, they both agreed, directed the broker Michael in writing to pay out the earnest money deposit to the courier son Stephen. So they put it all in writing and they signed it. Despite the fact that this action is not stated as a permitted disbursement in the sales contract. The sales contract doesn't specify about releasing earnest money to a seller. However, if the buyer agrees and the seller does too, and they put it in writing, then we follow those instructions. Because who do we represent? We are being paid by the seller or the buyer. So the correct answer here is A. Michael must disburse the funds as directed. You're going to say, wow, right? But yes, the key words here was that they directed the broker in writing to pay it out. We don't typically recommend that, and we would advise them of that. However, if that's their decision and that's what they want to do, then that's what will be done, and it will be specified right in the contract as an exhibit that will provide it to the title company or to the attorney, whoever the escrow officer is. So it says here, the written request is perfectly legitimate, and the broker is bound to obey the order. Court intervention is available for disputing parties, not parties acting through mutual agreement. So there's no dispute. They both agree, and it's in writing. So we are there to obey our principal's instructions. Even though it's not written in the contract, it would be added as an exhibit or an addendum to the contract. There is no per se addendum that states that. So it would be done on an attached written document. Okay. All right. Y'all got that? Let's see. Most of you answered B, which Michael must follow the provisions of the sales contract and refuse the directive. No. Okay. Yes, we follow what the contract says. However, they added an agreement in writing and gave us a direction, and we must obey that. And when in doubt, the sales agents can go to a broker. And so, see, who was it the broker or sales agent? Okay, they directed the broker, right? And so the broker has to go by and obey that. All right, number 17. Okay, Stacy, you entered 1311D. Okay, we're on number 17. Maybe you're answering 17. A home seller makes a legitimate written demand for a buyer's earnest money deposit following an undisputed buyer default. In this case, the broker should do what? Okay, so the earnest money is with the broker trust fund. A, must disperse the funds within 7 days of the demand. B, must disperse the requested funds within 30 days. C, must notify the buyer in advance of an imminent withdrawal from the trust account. Or D, must return all funds less any earned commission and marketing costs. That's number 17. So read the question carefully. A home seller makes a legitimate written demand and the buyer does not dispute it, does not dispute their default, right? So the specific performance has automatic liquidated damages, right, on the contract. And if the buyer doesn't dispute it, that means they signed a release of earnest money, and the broker, okay, must disperse the requested funds within 30 days. And why is it 30 days? Well, because it could take a few days to have the bank approve the check and make the funds available, but they're legally given 30 days in order to release the earnest money. Title companies do it much quicker. However, the checks have to clear and all that before any monies can be released, right? Title companies and attorneys and trust funds have to make sure that the checks have cleared. So you're given up to 30 days. They can do it in 5 days, 7 days, but a lot of times the checks that are deposited by clients, okay, it might take them, up to 10 days to clear at the title company or wherever they were deposited. Okay. So some of you answered A, must disburse the funds within 7 days. Well, you have to be careful about which funds. So B says must disburse the requested funds. Okay, the home seller requested the earnest money. They don't release all funds. Okay, they might have had extra, money in there in the escrow account. So only the requested funds. In fact, a release of earnest money form specifies the amount of money that is going to be released. It is not just all funds. Okay, and then you're allowed up to 30 days. All right, number 18. The trust fund documentation must be maintained by the broker for what period of time? A, 1 year, B, 2 years, C, 3 years, D, 4 years. Remember, how long do we have to keep our documentation for? That's one way to think about it. Going once, going twice, gone. The answer is D, 4 years. So trust fund documentation must be maintained by the broker for 4 years. In fact, all documentation, all contracts, we must maintain for 4 years. Very good. 4 years, Yesenia. All right. Everybody got it right. Very good. Very good. All right. Number 19. A buyer and seller have a serious disagreement about the payment for repairing defective water filtration system in the subject property. The subject property is the one that's being sold or bought. The buyer gives up and demands the deposit back. The seller disagrees, claims the buyer has defaulted, and demands the earnest money as liquidated damages. What should the broker do? That's okay, Crystal. See you next time. You can see the replay, okay, the recorded. And that way you can fast forward what you don't want to listen to. See you next time. All right, awesome. Have a good evening. So what does the broker do in this instance? Okay, when the buyer and the seller have a disagreement. A, follow the instructions of the broker's attorney. B, pay the trust money into pay the trust money into the registry of a court and let the courts resolve the issue. C, submit the dispute to the local board of realtors or arbitration. Or D, conform to the terms of the sales contract. So these two individuals don't agree. So the contract says they both have to agree to the release of earnest money, and they don't agree. So then what can happen? Remember, you have either they agree. If they disagree, they go to mediation. And then if they still disagree, they go to arbitration and a decision make. And then if they appeal that, they go to court. So obviously they're going to disagree the whole way along. So what do you think it is? No, the local board of realtors has nothing to do with it, Winston. Okay. And the local board of realtors basically is responsible for all the listings to be uploaded and photos, and they monitor the multiple listing service. Okay. So any disagreement about earnest monies or deposits or in the contract, it goes through mediation, arbitration, and then to litigation. So in this case, they disagree all the way along. They're going to go to the court. So the trust money or the earnest money will be pay the trust money into the registry of a court and let the courts resolve the issue, which is going to cost them more money. But it doesn't say how much the earnest money. What if it's a multi-million-dollar property? It's going to be a lot of earnest money in there. Or it's a commercial property, right? There could be a lot of earnest money in there. So it might be worth it to go fight it in the court, because if the earnest money doesn't get released because they don't agree, it'll stay in the trust fund at the title company or wherever it's being held. And then what they do is they either send it to the state or they distribute it to donations. Okay. So I don't know that for sure. I've heard that when those fund money stay in la la land at a title company or with an attorney and nobody submits a demand letter and they don't come to an agreement, they don't go to court, then it has to go somewhere. Okay. And that's decided by the title companies or the state as to donating it to a needy organization. That's what I've read in the past. So the answer there was pay the trust money into the registry of a court and let the courts resolve the issue, because basically they went through mediation, arbitration, and now they're in litigation. So very good, Miss Stacy. All right, number 20. A licensee wants to sell a subdivision lot she owns. What does the licensee have to do that is any different from a non-licensee selling the lot? So A, the licensee must provide current market value documentation. B, the licensee may not list the property with her broker. C, the licensee must tell the buyers that she is licensed as soon as they meet one another. Or D, the licensee must disclose her license status in writing before signing any contract. So a couple of answers seem like they're the correct answer, but one of them is the best answer. And that's what, the Pearson VUE test or the test center exam is looking for. So type your answer in the chat, please. That was one of the possibilities of being a correct answer, Allah. However, the answer is actually D. The licensee must disclose her license status in writing before signing any contract. So a contract is going to be signed, right, will be submitted. And before that licensee returns a signed contract, has to include a statement on there that owner is a licensed realtor in the state of Texas. Okay, and that can be added in the special provisions, or there's a section now in the contract that specifies if there's a relationship to the owner selling the property. So it doesn't matter what type of property we're selling. So a licensee wants to sell a subdivision lot that we own. What does the licensee have to do that is different from a non-licensee? We must disclose our status, okay, in the contract. Even before the contract verbally, or when we're showing the property, we must disclose that we are licensed in the state of Texas, or if we're licensed in another state. Okay, like when I was licensed in Oregon and I was doing business in Texas. And however, once we actually have a contract, we must disclose it in writing in the contract. And if it's not, then we've got to write an amendment to add that statement. So the answer is D. So yes, we must disclose as soon as we meet someone, we must disclose that we own the property and that we're a licensed realtor. However, we have to definitely put it in writing before finalizing and signing a contract and executing it. That has to be included in the contract. So C is correct, but that is done there verbally, okay? So for a contract, the best answer here is, what do we have to do? Is disclose her license status, okay, his or her license status in writing before signing any contract, right? Because the buyer is going to present the offer through a buyer realtor, or they're going to go to an attorney to have the contract written, and then it'll be presented to the owner that is a realtor, and then they will add the statement on the contract before signing it, then signing it if they accept it, and sending it to the buyer, right? The buyer has to acknowledge receipt of it before it becomes an actual executed contract. Allah, thank you very much. You're very welcome. So that is all the questions. We did, I think, 15 national and 20 state questions. So national questions that apply to all 50 states, and 20 Texas state questions. Okay, so those of you that are retaking your exams, remember to go ahead and go and study vocabulary again. All right, I keep repeating this, and so does Joe Juder on AgentPrep. And there's other videos, other YouTube channels that you can study from. Okay, I'm not the only one. I just only been doing this on YouTube for 1.5 years. I've been doing it in person and then on Facebook for almost 9 years. However, since then, many other YouTubers, many other instructors have started teaching real estate, predominantly national, on YouTube. And there are some very good ones out there that you can see. Some might be, faster than mine. Some will just read the question and the answer, question and answer. And that works for some, that's all they want. They don't want to deal with the explanation or the experience, or to understand it in more detail as I go through it. Joe has been doing it since, 2012 or 13, okay, something like that. And he also explains it, and he lets his students participate on a lot of his videos. And I like that style. And before I even knew him, I was doing the same thing with my students in person. Okay, so This is not something that I just started doing it, and I've been practicing real estate all those years. And I just started helping because of one young lady that, had taken it for 5 times and hadn't passed and needed a lot of help with math. And so I volunteered, I started doing it, and then I was asked to do it for more, and it's grown since then. COVID got me to do it on YouTube. Okay, COVID got me to do video. All right, and be exposed to the whole world because I was not a camera person except for my private little group on the private group on AgentPrep on Facebook. All right, so thanks again for making these videos. You have a good night. Oh, I will. Thank you so much. I enjoy it. I love you all. Okay. And I wish you all the best in passing your exams and becoming a licensed realtor. You'll be graduating, okay? And let me know so that we can congratulate you, or I can congratulate you. And then you can ask me about Exp Realty, because that's who I am with. That is my sponsor. And I'm under a group named Dream Team. We're not a sales team. We're actually a group called the Dream Team in EXP. Okay, it's an awesome company. We're a cloud-based company, a virtual company. Our office is on the cloud. We don't have brick and mortar offices unless a realtor, a broker already had an existing office and they moved their office to EXP and they kept their brick and mortar office. So there are some that have brick and mortar offices, but our type of brokerage is on the cloud. So because we don't pay all these brick and mortar offices expenses and overhead, we're able to share more of our commission with the realtors that actually do the work, right? The agents, okay, and get rewarded with stocks. And there's a lot of ways to get rewarded at EXP. And we have lots of technology, training, education, and all of it is done online. Some do it live in person, if they have sales teams that you pay an extra commission to for helping you. And realize, all of you, this is your business. This is not just a job or a career. It is your business. You're opening the door to your store. Okay. We are the boss of us. I'm the boss of me. You are the boss of you. Okay. So it's going to cost money to get your business going, and not an exorbitant amount, maybe $1,000 to pay all the application fees, all the MLS dues, national and state, in order to become a realtor. So get it correct. We are realtors, 2 syllables, not realtor. Okay. We are realtors. That makes us a professional when we are registered with our local MLS. We're a member of the local MLS, the Multiple Listing Service. We're a member of the State Association, and we're a member of National Association. We have higher credibility. We are professionals, and we get to open our own office. And with our company, you can market yourself, your branding. The only thing they ask is that we use the EXP name, and that's equivalent to all brokerages. Okay, so I have videos about EXP Explain. I have videos on here about tips to prepare for your exam, tips to studying, and what to do the night before preparing to take your exam. Like, don't cram the night before and don't get any sleep. Relax, and remember that you may skip the first 5 questions and the math for review, but give yourself enough time to come back and answer those questions after you answer all the simpler questions. Okay, because you have an opportunity on the exam to click questions for review. But as one of the young ladies mentioned, I'm trying to remember who it was that mentioned that I think it was Stacy, that she took the exams and didn't pass them, ran out of time, and didn't get to go back and finish the ones that she had clicked for review. Okay, so go through and answer all the quick, easier questions and come back to them, but make sure you do not take more than a minute per question. Okay, because once you finish the national exam, boom, that's it. You start the state, cannot come back to the national. In other states, it's all combined, national and state. In Texas, we have a national exam with 85 questions, and we have a state exam with 40. However, you get graded for 30 on the state exam, right? You get a score. You have to pass 21 out of 30. And why do you take 40? Because brokers also take these exams. And on the national, you have to get 56 out of 80, right? So, out of the 85. So you're graded on 80, right? 70% of 80 is 56. So brokers take the same exams, but more questions. Okay, y'all. So let's see what Stacy said. Oh, no. Anybody else? All right. If no further questions, hey, remember, if you haven't been to YouTube Agent Prep, please go to my channel and tap that subscribe button. Click that little bell so you're reminded every time I go live, and give me a thumbs up. Send me some love so that I could continue creating more and more videos for you and even better education on helping you get your business started. Until next time, y'all, this is Wild Lily Handy from YouTube Agent Prep, coming to you from San Antonio, Texas. See y'all later. Saturday. Bye.